when the question is there.
But it's not a challenge. Yeah, it's an interpretation. It's not a challenge. On challenge, of course, you have to hear the Attorney General. Otherwise, wherever Central Act is involved, we'll have to start hearing the law officers for the government. We should, in a given case, you may find it necessary to
ultimately,
do so.
Lordship have to read down a provision of the Central Act. That is my, if Lordship permission, if I may read that.
And fortunately, solicitor is already here, not necessary.
That judgment is not necessary.
That was the Bhuyan judgment of 2023. Judgment is of Justice M.
Give us the citation.
Lordship. Well, the reference order is of 2015, 12 SCC.
2015,
12 SCC, 702.
704.
702, my lord.
Yes.
And my lord,
What the party?
My lord, the party is Arup Bhuyan versus State of Assam. That is in 2015. Thereafter, my lord, it was answered recently in 2023, just before Justice Shah retired, my lord. The SEC citation is not there. Online citation is there, my lord. 2023 SEC online SC 338. Your Lordship permits, I can just read one paragraph where it has been answered. So I'm reading paragraph 64. Now, so far as the reading down of section 10A1 of UAPA 1967 by this court, in the case of Arup Bhuyan is concerned, at the outset it is required to be noted that such reading down of the provision of a statute could not have been made without hearing the Union of India and or without giving any opportunity to the Union of India. 65 mirror, when any provision of parliamentary legislation is read down in absence of Union of India, it is likely to cause enormous harm to the interest of state. If the opportunity would have been given to the Union of India to put forward its case on the provisions of section so-and-so of UAPA, the Union of India would have made submissions in favor of section 10A of the UAPA, including the object and purpose of the enactment of such a provisions and even the objects and purpose of UAPA. The submissions made by Shri Parikh, Learned Senior Counsel, relying upon the decision of the court, Sanjeev Koch, that it is ultimately for the court to interpret and read down the provisions to save any provisions from declaring as unconstitutional is concerned. It is true that it is ultimately for the court to interpret the law or particular statute. However, the question is not of the power of the courts. The question is whether can it be done without hearing the Union of India. This has been answered in affirmative in para 100.
This was a case where otherwise the provision would have been unconstitutional. Therefore, it was read down to save it from the vice of unconstitutionality.
There was a specific
when a challenge is to a provision on the ground of unconstitutionality, in any case, if it's a central statute, the Union of India has to be heard, the Attorney General has to be heard. So necessarily, when you are reading it down, equally you have to hear the AG. So this will not apply here really. And that was a case where, there was a broader power to arrest. That was challenged as unconstitutional. That was read down by the bench in the early judgment. That's right.
Now, coming back to the coming back to my submissions, yesterday, I was reading the table which categorizes the vehicles in two categories, that is transport vehicle and non-transport.
Yes.
The point I was making, Lord, the motorcycle for hire to carry one passenger. This is the
Which page of the submission are you on now?
it's page 7. There's a table, Lord.
Yes. Yes, yes.
Point 3, my Lord, I am stressing upon. There are about 21 categories of transport vehicles and 15 categories of non-transport vehicles. This is a table for the purpose of section 41 of the MB Act, my Lord, which provides for registration of vehicles.
So what is
My
the submission?
respectful submission, my Lord, if the motorcycle whose weight would not exceed more than 200 or maybe 200 kilos with a pillion rider is categorized as transport vehicle, and there are SUVs which can be driven by LMV license, which have the weight of anything between 2,500 kgs to 5,000 kgs, my Lord. And you know, every day we see accidents from SUVs. And you know, I think that in my humble
So
submission,
according to their large SUVs, or heavy SUVs which can be
Yes.
driven with a. On the other hand, there are smaller transport vehicles.
yes,
Each one, Devvrat, must be seen in the context. If you see subsection 4 of section 41, the purpose and object of such a tabulated form is only, as it says, it shall also specify the type of motor vehicle, being a type as the central government may, having regard to the design, construction and usage of the motor vehicle by notification in the official gazette. So the registration provision requires different facets to be recorded in the registration.
that's it.
And apart from other things, it also says the type of things which are required to be recorded is specified in here.
That's right.
And
So the
ultimately, the
context is slightly
exactly. Context is very different and the purpose of the use is different. After all, a transport vehicle is used for a very different purpose than even say a large SUV. You're right. I mean, but as it is always said that these aberrations cannot result in the provision being declared unconstitutional, even if there were a constitutional challenge. But more importantly, these are, of course, there are these exceptional cases where you will have a small transport vehicle as opposed to a heavy SUV for which the driver. But look at the purpose. Somebody who is driving an SUV, the presumption which the law makes is that you're not driving it for, it's not in the nature of, say, a school bus, or you're not driving it for carrying of goods or passengers for hire or reward. The purpose is very different. The nature of the people who are in the car is different. In the sense that, in one you have passengers who come in for hire or reward.
In my humble submission,
You would want us to interpret on the basis of this. This is an executive order. But we are really looking at, it might be even wrong. Let us assume for a minute that this prescription or categorization is contrary to the statutory scheme. But then to use this to interpret the statute will be, reversing it. Your purpose is to only for interpretation, right?
Lordship, please.
That we should not be doing it. We can't
So my
interpret the statute.
limited submission is this.
Executive interpretation. Motor Vehicles Act.
What happens if this is categorized as transport vehicles, and tomorrow, if unfortunately this vehicle meets an accident, and just because the person is holding an LMV license, he will not get the claim. The claim will be repudiated, even if it is a personal vehicle.
doesn't. License, it doesn't. This execute doesn't entitle somebody for a licensing or licensing. It doesn't work like that.
I mean, just to Milord,
No,
show
fine.
what is transport and what this is the only place where it has been categorized as transport and non-transport vehicle. Where Lordship will find a personal vehicle also being categorized as non-transport vehicle, which would ultimately come to the rescue of person if he is driving it or using it as a transport vehicle, and if it meets with an accident. Able to recover his claim and say that the vehicle was for personal use.
But one other thing, any of these under the non-transport vehicles are used for purposes other than a personal purpose, then the other provisions, statutory provisions get attracted. So it's not applicable across the board
I
to
appreciate.
define a non-transport.
I appreciate.
Okay.
This is the only distinction in the act.
How do you formulate it in your submissions? Let us see your submissions, so
Not-
that we'll then you can leave the point after we've
Not-
read your submission on this.
Because I was reading para 5, Milord,
Para 5 already.
page 2. It is clear that legislative intent is clearly to replace above said classification with single class of transport vehicles. This was 94. Thus, the expression transport vehicle would include only the heavy goods vehicle as in section 216, heavy passenger motor vehicles as in section 2, clause 17, medium goods vehicle as in section 2, clause 23, and medium passenger motor vehicles as in section 2, clause 24. However, the classification of LMB remains unchanged in section 10, clause 2D as a separate class. In fact, Milord, Mukund Devankan also held similarly. Para 6, therefore, the three-judge bench in Mukund Devankan has rightly held that the legislative intent behind the omission of clauses E to H from section 10(2) of the MV Act 88, insertion of expression transport vehicle in section 10, clause 2E, is to give effect to the provisions of section 3 of the Act, which requires that a person, in order to drive a transport vehicle, must have authorization. Once a license is issued to drive light LMV, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight or motor car, road roller or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kgs. As I started Lordship yesterday, everything boils upon the weight. And till date, my lord, this regime, my lord, since 1988 till date, about 40 years, it's holding ground. It's only
So your
weight-based.
contention really is, Devrat, that therefore, after the amendment, interpret the expression transport vehicle after the amendment in section 10(2)(E), so as to exclude those transport vehicles which fall within the definition of light motor vehicle.
Lordship. That will create problems.
And no, you are saying if you include all transport vehicles
Absolutely.
in 10(2)(E), including those which otherwise fall within the definition of LMV, then it will create this anomaly, which you said that even small transport vehicles would be within the ambit of the statutory provision in 10(2).
That is what my contention, my lord. Then para 7, my lord, LMV license means a license to drive a vehicle weight not exceeding 7,500 kg, which would also cover a vehicle which happens to be carrying any goods kept therein. For instance, where a person having an LMV such as Maruti van is carrying goods for personal occupational use. That was my contention.
Parliament has to step in and amend.
originally, my lord, it was 6,000. By way of amendment, it was increased to 7,500. The weight. Right, my lord, I'm reading. Therefore, the expression LMB would extend over vehicles which happens to be carrying household goods and other goods of daily uses, such as certain professional like medical equipments and all, for doctors, even for lawyers, books and files, and for people like who do interior decorations and all, who routinely carry goods in their personal vehicles. If all these vehicles happens to be transporting goods which have their weight less than 7,500 kgs are classified as transport vehicle, then in that case, large number of insured vehicles of the country like India would stand to lose the insurance benefits on the pretext of being a transport vehicle. If in case such vehicles are found to be carrying goods in it.
You have written in para 8, say, medical equipment, doctor. But the Chief Justice of India is working very hard to take away files and books for the lawyers to qualify as a good vehicle.
I was coming to that.
You don't have to carry all that big burden.
Lordship, we remember those
Justice
days.
Narasimha's car would have been much lighter now if he was at the bar. He would have been carrying only his
Earlier, transport vehicle.
a transport vehicle he would require earlier.
Lordship, there used to be thousands of bags outside. Now we see much lesser bags.
Yeah, you think it's been it's impacted, no?
We used to have trolleys
Yeah.
hauling the bags.
Even for us over here, there used to be in the morning when we used to come to the court, you would see there were these contractual staff carrying stacks and stacks of files on their shoulders. Then we say, what is this? At some point of time, their shoulders will give way. Then they had trolleys. The trolleys would be lugging all the briefs.
Trolleys
That's also
came-
come down now.
Trolleys came much
Airport.
later.
The airport, people used to have an objection because weekends when judges go out, baggages used to go out for files.
Yeah, you can.
Huge baggages.
One particular, perhaps Chief Justice would recollect also, Senior Advocate Govind Mukherjee.
Yes.
He used to carry his own.
Yes, yes,
Yeah,
yes.
yeah. Mr. Andyarjun also, my senior.
And the Arjun
Mr.
also.
Andyarjun now carry his green satchel.
He's
Satchel.
actually embroidered that.
Yeah,
Yes.
embroidered.
Well, he was my senior also. So sometimes we used to help him with the bags and
Devrat was Mr. Andyarjun also.
yes, but he used to say, no. Let me also hold one side of the bag. So that was his style.
Of time.
In
That
fact,
old tradition in Mumbai came because the chambers were very close to the court, right? So the lawyers would carry their own brief and go to the court with the brief in hand.
Mr. Andyarjun used to say that Mr. Sirve used to carry all his briefs.
All his briefs himself.
And sometimes he used to travel in the local train also, carrying his briefs. great thing, because he used to have just one matter a day, not more than one. He used to take just one matter.
And there was another tradition in Mumbai. You see, they used to have those bags, the brief bags, which were embroidered, no, with your initials. So if you performed well in a matter, the senior would present you with a brief bag which your own embroidered. So nobody bought those embroidered bags themselves. You see,
Right.
you waited until a senior recognized you. It was one of those traditions. The senior would recognize you for. And it was always blue for non-designated seniors and red for designated seniors.
It's a great touch.
Like the gown.
It was always a gift from a senior.
You have to earn your spurs.
Yeah,
as
the
they
gown
would
was
say.
always presented.
Even the gown also.
Gown always was presented when you became designated.
Mr. Ngarjuna got a gown from Mr. Sirve.
Likewise, I got my gown from him, when I was designated.
So many of our juniors who came later on, he said the gown is torn and all. Why don't he change? I said, never tell him to change. He'll never change it.
Justice Nageshwara gave mine.
Oh, I see.
The senior gown.
So 8 is over there.
That's it. I was
Nine.
reading
Come
the
to nine.
bottom.
9 now we'll take.
Para 8, my lord. I was just finishing. Therefore, in my respectful submission of the respondent, criteria of weight is important to distinguish between transport and non-transport vehicles and grant of licenses to drive such vehicles.
It could be one of the criteria. You can't be saying the criteria because there are so many other, say, licensing regime. It has very distinct between the two categories. So you can't say that this should be the only factor.
Well, it's my submission, in my humble submission, my lord, the LMV and HAV are the two, in the licensing regime, are the two great distinguishing factors. For LMV, it is different. The whole contention is revolves around LMV. HMV, it is different because of the load factor. It's based on weight only. Para 9, madam. In difference to the contention of the petitioner with regard to the compliance of section 7(1) of the MVR for driving a transport vehicle, it is respectfully submitted that as per the definition contained in section 221 of the Act, LMV includes a transport vehicle which does not exceed 7,500 kg, and therefore a person holding a license to drive an LMV is deemed to be authorized to drive a transport vehicle which does not exceed 7,500 kg in weight. Thus, a license to drive an LMV issued under section 10(2) also extends to driving a transport vehicle in the same weight category as provided in the Act.
The table at 10 you have already discussed.
10, I've already discussed.
Go to 11.
11 is one humbly states that the legislative wisdom has correctly defined the transport vehicle weight up to 7,500 kgs as an LMV and can be driven by a person who has been issued a license for driving an LMV. This honorable court in a decision under reference has correctly interpreted the meaning of the transport vehicle in consonance with the intention of the legislature as laid down in section 221 of the MP Act 1980. In order to substantiate my arguments, the few paragraphs of the judgment, I'll read where it has been fairly rightly articulated that how 221 is an important aspect of the Act and it cannot be overlooked because of other provisions.
Which paras, Devra?
Para 17 in the middle, I will read. Placetum C.
You're referring to what exactly? I couldn't get that.
I'm only
Judgment. You were talking about some judgment.
Lordship, the Mukund Devangan judgment.
Mukund Devangan.
I'm sorry. I'm reading para 17, my lord. 70. That is at page 74 of Mr. Dave's compilation.
Which is worrying is
thing which is worrying, that, which is troubling, that apropos what Mr. Devrat argued, Mr. Kaul, the result of this would be that all those transport vehicles which fall within the ambit of the definition of light motor vehicle and which are less than 7,500 kgs by weight, they will all get out of the insurance cover. So smaller transport vehicles. If we take this construction, which you have suggested, which prima facie, I mean, we indicated to them also is a correct construction, but can't ignore the fact that then they will lose the insurance cover completely. Smaller
vehicle will not lose the insurance cover. It is only when it is driven by somebody who only has an
That's what we are saying.
license.
That there will be no insurance cover if the driver was basically a driver of an LMV.
That
But
will happen.
the moment it is driven by a driver,
Say Maruti van.
That will happen a lot in every case where a driver who doesn't have the correct kind of license drives a vehicle for which he is not authorized to drive. In every case that will happen. So therefore,
no, it's the driver.
It's the driver who's not validly authorized to drive the vehicle for any even a transport vehicle above 7,500. If a person who is not entitled to drive, whether under or over, is driving a vehicle of a class that he is not authorized to drive,
But
it's
then
not the vehicle at all.
No, not the vehicle, you're right, but I said that by mistake, but the consequence would still be that
he is not
people
having
are
the
affected by an accident involving a vehicle which was driven by a person who only had an LMB license and therefore by necessary implication excluded from driving
therefore
a
I have a suggestion.
small transport vehicle.
Your Lordship's concern is
Lose
right.
the benefit
Although that is
of,
not something that will happen.
compensation.
Supposing you drive a large bus which is more than 7,500 kilos, the same thing will happen. If you drive it with an LMB license, you will not have the insurance cover. That will always happen if you do not have the correct license authorized to drive that vehicle. Now,
But within 7,500,
correct.
within 7,500, Mukund Devangan would have extended the benefit
Right.
of
So therefore, I had a
the
suggestion.
remedial provisions of the Act.
I had a suggestion, my lord. Your lordship yesterday mentioned about prospective overruling. Now, so that it is made clear that henceforth, in any case, you cannot with an LMV licensed drive a transport vehicle. But in prospective overruling, there are two things that I was suggesting. One was that where some court has given you compensation which has been paid, that will not be reopened. Nobody will have to give back that compensation. The other was because of the confusion that Mukund Devangan created in 2017, people may have been thereafter thinking that they are authorized to drive with an LMV license, a transport vehicle less than 7,500 kilos. So if the accident has happened between the date of Mukund Devangan and your Lordship's judgment, in case, my lord, it comes in our favor, then that will not be governed by, my lord, your Lordship's judgment, but will be governed by Mukund Devangan. These are the two
Classical
exceptions.
prospective.
Yes, so these are the two exceptions, namely, my lord, one. Yes.
knowing in life, it's not unimaginable that light motor vehicles get to be driven by persons who have only non-transport licenses. It's possible. In all such cases, even if we say a prospective overruling,
Lord,
that situation emerges and continues to happen in the country.
it may
So
happen
in
that
all such cases,
heavy
insurance
motor vehicle
company
is
will
also used,
choose
my
to
lord, by a
drive.
person.
Insurance will say
In
that
all
well, I
such
can't take
cases-
compensation.
But we are contrasting it with the realities of life. So in
Not the
reality, this is what is going to happen,
Yes.
that somebody will drive a transport vehicle, light motor vehicle, though we have declared the law, but that's going to happen. invariably somebody will.
But that surely, my lord, that.
And a large number of cases will be there, but that segment of the
So
population.
my answer to that is
Lose
that
it.
that cannot, my lord, determine.
We
There
understand
is-
that.
There is a
We are
defense.
only
Legality, we are just impact, we are the
flagging a
consequence.
concern.
Correct. That's why I was saying, Lord, that your lordship's concern may be valid to the extent that because of the confusion created by Mukund Devangan, people have been driving it thinking that they are authorized to drive it. So that class of cases can be accepted. Otherwise, my lord, a person having no license can drive a vehicle.
Absolutely.
It happens, my lord, many people drive without licenses, even though the car is insured. Now, can it be said that, well, because of that, the insurance will not be valid,
On
therefore,
interpretation, we don't need.
I'm not just on the interpretation, I'm on the impact of it also. Lord, the
But also
whole
you are-
point is the insurance company has insured the vehicle saying that I am giving this insurance only if a person who's competent to drive this vehicle drives it. Otherwise, I'm not insuring it. So therefore, my lord, can the insurance company be told, sorry, even though you insured it for a person having a valid driving license, but it happens in life that people without driving licenses drive it, so the insurance will have to be.
We can reduce the legal license, it's going to be prospect.
Section.
The only way out of that your lordship may have to give a window period after the judgment, get the license.
In fact, my lords, what will happen is,
Publicity of the.
what your lordship is
environment.
suggesting will actually encourage people to now take an endorsement on their license, which was till now not being taken. That will also be with publicity, and if your lordships are to vote in our favor,
And
would
to get an
encourage them to
endorsement.
take an endorsement.
To get an endorsement, it is like, upgradation.
Yes.
So you need to undergo the training, you need to undergo the health checkup and things.
But otherwise the impact would be on the day of the judgment, there would be lots of people who will go jobless, especially people who are driving Uber and all, my lords. Ola, on the strength of the LMB license, jobless the day the judgment comes out.
Do that's in 4 months.
There's a social angle to this. But there is a social angle to this. The point I am making is that
Or please see section 150. Section 150 is a defense which is made available by the statute to us, which says that if you do not have a valid driving license, then the insurance policy will not be valid.
Right.
That all we are with you, Mr. Bhushan. There
I'm
is no
sorry.
difficulty on that. We are not.
So therefore,
not against you on that.
The moment your lordship says that even though a transport vehicle will not fit within the contours of LMV, and if you have a license to drive an LMV, you will not be authorized to drive a transport vehicle. But if you have done so, the insurance policy will still be valid. That would be totally contrary, my lord, to the provision of the Act.
That we have heard you, I mean, now. Yes. All right, let's, Mr. Devrat, complete. Devrat, now we've seen your submission. Anything else that you want to?
Lordship, I just want to read few paras.
Para 17.
Yes, we've noticed that.
Custom C, I was reading from the middle. The provision of section 3 of the Act requires that a person, in order to drive a transport vehicle, must have authorization once the license is issued to drive motor vehicle. It would also mean specific authorization to drive a transport vehicles or omnibus, the gross weight of the motor car, road roller or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kg. The insertion of transport vehicles category in section 10(2)(e) has no effect of obliterating the already defined category of transport vehicles of the class of LMV. The distinction is made in the Act of heavy vehicles, heavy passenger motor vehicles, medium goods vehicle, and medium passenger motor vehicles on the basis of gross vehicle weight. That is my contention, my lord. Or unladen weight for heavy passenger motor vehicles, heavy goods vehicle, as the case may be, exceed 12,000 kgs. Medium goods vehicle shall mean any goods carriage other than LMV or HMV, whereas medium passenger motor vehicles means any public service vehicle or private service vehicle or educational institution bus other than a motorcycle, invalid carriage, LMV or HMV.
Thank you, Ms. Devrat.
Lordship, just one paragraph, if you lordship
Yes.
may.
We'll hear some, yes.
Lord, para 39.
Para 39 of Devangan?
Devangan, Lord.
All right, we'll make a note of that.
Then your lordship may kindly also, my lord, make a note of para 55 and 58.
Okay.
My lord, 39 actually summarizes everything, Lord.
Yes. Thank you, Ms.
Lordship. Thank you.
Yes, thank you, Mr.
Thank you, Lordship.
Yes, Mr.
May it please, my lordship. My submission will be, my lord, basically twofold. The first part of the submission is on the very basic interpretation of the definitions and the provision under the Motor Vehicle Act. The other fold of the submission will be on the point that the impact is already secured. I will point out that as well at the end, my lord.
So first, what is the first
So
submission?
if my lord would please have a fresh look on the aspect of the definition. So if we have a bird eye view on the definition aspect, so we have a class of vehicles which is as per the weight. We have a definition of a light motor vehicle which is up to 7,500. We have a definition of heavy goods vehicle and passenger motor vehicle, heavy passenger motor, which is in section 2 clause 16 and 2 clause 17, which is also exceeding 12,000 weight. We have a class of medium goods and passenger vehicle, which is defined in section 2 clause 23 and 2 clause 24. There is no specification with respect to the light goods vehicle or light personal vehicle, light passenger vehicles. And my lordship, all these definitions are very interconnected as far as the weight is concerned. The other aspect is the kind of vehicle and the name of vehicle. So if you have a bird's eye view, as far as the definition is concerned, we have a class of vehicle which is purely on the basis of weight. We have a kind of vehicle. And we have a name of vehicle. It is interesting to note that the name and kind of vehicle does not specify any weight in it. There is no there is absolutely no mention of weight in the name and kind of vehicle. I will take for example, my lordship, if we see section 2 clause 21, my lordship, may please see the act now.
Have you formulated it, Kaustubh?
My lord, I have
No, what you're saying,
my
have
written
you
submission, but in
formulated-
a very short form, but I'm just expanding it, my
No,
lord.
no, I'm just asking, have you formulated what you said? No.
Yes, ma'am.
You've given us written submissions?
There is, my lordship. But my lordship, what I am right now argument is beyond my written submission.
Yes, you got
Okay,
it.
then you can go
So-
ahead.
Now tell us, just to take it forward, you're
Yeah.
saying there
Three
are
categories.
three categories.
See section
Class
2
of
clause
vehicles,
21.
what class of vehicles based on weight? Just give us which are those provisions so that we can
Yes,
just
ma'am,
take
please.
it.
Section 2 clause 21 first, it is for LMV, which is up to 7,500.
Just do the numbers.
Yeah.
Yes, yes.
221, then?
216 and 217, 223 and 224. And all these definitions are very perfectly interconnected, my lord.
Okay, now, so far as those vehicles which are go by name, non-weight, what are
yes,
those?
sir.
A kind of vehicle without reference to weight. That's the
Yes.
second thing. Which is that?
Yes.
Kind of vehicle without reference to weight.
My lordship, first is the transport vehicle,
Clause.
247. There is a tourist vehicle, 243.